Hi, today I wanted to comment quickly on a ruling that's just come out of California with respect to Uber and Lyft drivers. There's a big fight over there about whether the Uber and the Lyft drivers are employees or independent contractors of those companies. It's a huge business issue worth billions of dollars, and it gives some insight into the employer versus independent contractor dichotomy that applies oftentimes in employment relationships in Arizona and California and elsewhere. The claims relating to this fight is on one side that, well, you're going to put people out of work if you don't let these drivers act as independent contractors, and many of the drivers do want to work independently. On the other side, people argue, well, it'll prevent big companies from taking advantage of people if we make these changes, and these drivers really in practical terms are employees and should have the benefits that are accorded to employees. It came to litigation, as these things usually do, and the trial court judge out in California in August ruled that there was an overwhelming likelihood that after trial the drivers would be found to be employees rather than independent contractors. For the state to prevail and for the drivers to be found to be employees, the state had to meet a tough standard. It relates to whether a preliminary injunction can issue. And essentially they had to prove that there's a strong likelihood of the state prevailing and also a serious harm to the public if the trial court didn't immediately impose an injunction. And the state managed to meet both of those requirements, which really means that there's a very strong likelihood that after the trial that the Uber and Lyft companies are going to, end up losing on this issue. The court referred to California law that states that a worker is an employee unless three conditions are all met. First of all, the worker is free from the control and direction of the hiring entity in connection with the performance of the work, both under the contract and in fact. Second, the worker performs work that is outside the usual course of the hiring entity's business. And third, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. So the second requirement is a really tough one for Uber or Lyft to prevail on. The trial court said, and here's a quote from the case, "It's this simple. Defendants' drivers do not perform work that is outside the usual course of their business. To state the obvious, drivers are central, not tangential, to Uber and Lyft's entire ride-hailing business." Now, the ruling that just came out in late October consisted of the Court of Appeals agreeing with that holding by the trial court. It can still be appealed to the California Supreme Court, and the ruling's on hold until there's a final decision. So it's not final yet, but honestly, it's not looking great for Uber or Lyft in this litigation. There's also a proposition, Prop 202, on the ballot in California that would allow ride-hailing and food delivery apps to keep their drivers as independent contractors and have some of the protections that are afforded to employees, but not all of them. That's coming up for a vote this November, and we'll see what happens. And all of this, of course, is based on California law. But there's similar law at the federal level and in Arizona. And it really is a relevant issue to many employers that we deal with, both in California and Arizona. We have California attorneys here and also Arizona attorneys. Most of our clients are in Arizona. And so even this California case is important because it gives some light into that ongoing independent contractor versus employee fight. There's always an issue of whether the conditions to be an independent contractor have been met. It comes up in cases about unemployment benefits, about tax cases, comes up in overtime cases and wrongful discharge cases, and really a lot more. I tell my employer clients, look, you've got to be really careful about this. Just saying that a worker is an independent contractor is not enough. It's not close to being enough. You have to make sure that you're complying with the law and that you go through the different elements that determine whether an employee or whether a worker is an employee or an independent contractor. You got to figure that out in advance to make sure you're not liable for possibly a really big damage issue from the state or from a former employee who was treated incorrectly as an independent contractor. There may be in your business, if you're a business owner, there might not be billions of dollars at stake like there is in this Uber Lyft case. But you can really suffer a lot of harm if you're not careful about this independent contractor versus employee issue. And at Denton Peterson Dunn, we're always eager to help our clients avoid a legal morass by careful preparation. So if you have questions about the independent contractor versus employment issue, please do give us a call.